We're very glad that we have an international expert in international humanitarian law with us. Dr. Eitan Diamond is from Israel. He knows the Israeli system from the inside, and he can give us a testimony of the repression that is currently going on. And he can give us an insight into what obligations third-party countries have to intervene in this current crisis of international law. So please give us a warm welcome for Dr. Eitan Diamond. Thank you.
Thanks a lot. Yeah, thank you very much. So I'm really honored to take part in this sad but crucially important event. And as was indicated, I'm going to be speaking about the law and in particular about the responsibility of third states. So at some point, my talk might become a little bit more technical, but I wanted to begin with some other observations that put the law or the legal discussion about third state responsibility into context to a degree. So reflecting on the last 2 years during which we witnessed an onslaught on Gaza that has resulted in unfathomable human suffering accompanied by an escalation of violence and oppression, dispossession, and displacement in the West Bank, I find myself identifying very painfully with the sentiment that Albert Camus articulated in 1946, just after the Second World War. What he said was, "The years we have gone through have killed something in us. And that something is simply the old confidence man had in himself, which led him to believe that he could always elicit human reactions from another man if he spoke to him in the language of common humanity. The devastation of Gaza, which placed the very survival of its population under threat, was facilitated through the combined effect of three types of zones. Two of these zones were in Gaza itself. First, as Israeli forces advanced their campaign, they directed the population to leave the areas they were attacking and established what they called militarized zones. These were sometimes, perhaps more aptly, also referred to as killing zones. In these zones, which Palestinians were prohibited from entering, well, these zones actually, at some point in the war, they comprised more than 85% of the total territory of the enclave. So Palestinians from Gaza were prohibited from entering more than 85% of their land, and this land was placed off limits for them, and very much contra to the requirements of international law. Israel then proceeded to operate as though there were no civilians or no civilian objects within them. So these were, as I said, killing zones. And those who nevertheless remained in these killing zones faced terrifying conditions where their lives were under constant threat of being cut short. In many cases, they were. The remainder of the territory, so at times less than 15% of the territory, was referred to by Israel in a manner befitting Orwellian newspeak as humanitarian zones. In these zones, the population, millions of people, were cramped into tightly confined spaces where they endured deprivations so severe that starvation took hold. So these are the two zones that facilitated the atrocities in Gaza. But in addition to these zones in the territory, there was another zone outside the territory that contributed both to the atrocities in Gaza and to the oppressions that Palestinians have endured in the remainder of the occupied Palestinian territory. And this zone, for this zone, a terrible term from history, I think, provides an uncomfortably fitting metaphor. So I can't say it in the German. In the English translation, we speak about the zone of interest. This is a space where the tragedy is known, or should at least be known, but it's denied and disregarded so that people can carry on with their lives as normal. Now, this zone, external zone to Gaza, which facilitated so much of what we've been witnessing, both in Gaza and in the rest of the occupied Palestinian territory, occurred first and foremost in Israel, where most people, caught up with their own pain, anger, and trauma, seem to embrace a kind of indifference or denial about the atrocities in Gaza. Hatred, reinforced by dehumanizing language about, these are all quotes, human animals, barbarians, beasts, bloodthirsty monsters, all metaphors that we use to describe Palestinians in Israeli public discourse. So this language was such that many justified, and in some cases even celebrated, the destruction of Gaza. This occurred even while, in some places, you could actually feel the ground under your feet tremble as the nearby enclave was being pounded by Israeli bombs. Some in Israel, and many in civil society elsewhere in the world, did not succumb to this kind of indifference. They took to the streets, launched flotillas, and engaged in many other laudable efforts to bring the carnage to an end. But these outcries, in what Camus called the language of common humanity, did not elicit that human reaction that he spoke of. It didn't elicit that reaction from those, first of all, directly responsible for the outrages, who continued for 2 years and would probably have continued further if there wasn't a constellation that prevented it. They may yet do so. And it also didn't prevent others with the most capacity to influence Israel. And I'm referring here to third states, and particularly to those third states with strong political, economic, and cultural ties with Israel, and with the capacity to influence it most. These states, like people in Israel, found ways to avert their gaze, or at least not to register the full magnitude of the horror, and failed to take effective action to prevent it. In this regard, Germany is especially notable. I realize, of course, that the atrocities of the Holocaust have had a stultifying effect here. But surely the most important lesson that we should all draw from that history is that human dignity must always be respected, and that these sorts of crimes should never be perpetrated by anyone against anyone. Germany and Israel, perhaps more than almost any other state, should know this. Thanks. So up to this point, I've alluded mainly to a moral imperative. In the remainder of the talk, I'll do what I was actually invited to do, and that's to provide a brief account of what is legally required of third states in response to Israel's actions in the Palestinian territory under international law. For many tens and probably hundreds of thousands in Gaza, it's too late. Their lives have already been lost or destroyed. But it remains crucial that states will yet do what the law requires of them. At stake are not only the lives and well-being of the Palestinians across the whole of the occupied Palestinian territory, but also a law-based international order that was set up in the wake of World War II, and the political and humanitarian values that that world order was supposed to protect. So I'll turn now to give you a little bit of account of what's happened so far in legal discourse. If there are any questions, though, at this point, I can stop to take them. Otherwise, I'll get to a little bit more technical part of the talk. So the catastrophic developments in the occupied Palestinian territory have attracted the scrutiny of international courts and other accountability mechanisms. And I'll run through some of these. So first of all, in December 2023, 2 months into the hostilities, South Africa instituted proceedings against Israel before the International Court of Justice over alleged violations of the Genocide Convention in Gaza. On 3 occasions, in January, March, and May 2024, the court found the rights invoked by South Africa to be plausible and issued orders on provisional measures, essentially demanding that Israel ensure its armed forces and other organs do not commit genocide or other prohibited acts, and that Israel allow for the safe passage of humanitarian assistance at scale to reach those in need. You'll perhaps would have noted the dates I mentioned, so January, March, and May 2024. What the court called Israel to do obviously was not done, and many, many people paid the price as a consequence. The second development before an international court occurred in July 2024 when the International Court of Justice issued a landmark advisory opinion on the legal consequences arising from the policies and practices of Israel in the occupied Palestinian territory, including East Jerusalem. In this advisory opinion, the court held that Israel's continued presence in the occupied Palestinian territory is unlawful and must be brought to an end as rapidly as possible because it violates the Palestinian people's right to self-determination, as well as the prohibition of the acquisition of territory by force. The court also set out comprehensive obligations for third states, which I will speak about in more detail in a moment. Again, the court was very clear. This was in July 2024. It said that the illegal or unlawful presence of Israel in Palestinian territory should end as rapidly as possible. That has, of course, not happened, quite the opposite. Third, in November of last year, the International Criminal Court issued warrants of arrest for Israeli Prime Minister Benjamin Netanyahu and for former Israeli Minister of Defense Yoav Gallant for war crimes and crimes against humanity allegedly committed in Gaza at least between 2023 and May 2024. These crimes included the crime of starvation of the civilian population as a method of warfare. I mentioned those dates, but this, of course, continued thereafter, and we saw famine take hold in Gaza later on. A third warrant of arrest was issued for Mohammed Deif, the former head of Hamas's military wing, but that was withdrawn after he was reported killed. There may also actually be further warrants of arrest that have not been made public. There certainly are many Israeli officials who committed international crimes. Fourth, in September this year, the UN Independent International Commission of Inquiry on the occupied Palestinian territory, including East Jerusalem and Israel, concluded that Israel's actions in Gaza amount to genocide. This follows similar reports by civil society to the same effect, for example, by Amnesty International, by Physicians for Human Rights, an Israeli NGO, by B'Tselem, another Israeli NGO, by Al-Haq, a Palestinian NGO, as well as multiple reports by UN Special Rapporteur on the situation of human rights in the Palestinian territory occupied since 1967, Francesca Albanese. And there have been others who have alleged that genocide has been committed. And the factors that led them to believe that genocide was being committed continued after they came out with those statements. Finally, last Wednesday, the International Court of Justice issued a second advisory opinion on the obligations of Israel in relation to the presence and activities of the United Nations, other international organizations, and third states in and in relation to the occupied Palestinian territories. In this, the court held, amongst other things, that Israel has an obligation to agree to and to facilitate, by all means at its disposal, relief schemes on behalf of the population in the occupied Palestinian territory, so long as the population is inadequately supplied. Obviously, the population in Gaza was inadequately supplied for a long time. This includes an obligation to ally UNRWA, which was the main UN agency providing for Palestinians to do so. So this is a little bit of an overview of what's been done in international fora. And as you might have been able to appreciate, there's a gap between what these international institutions said the law requires and the reality on the ground. And those situations introduce they raise questions, but they also involve obligations of various actors. So I'll say a little bit about the states and their related responsibilities. First of all, some states have actually taken encouraging steps in response to the catastrophic situation in the OPT, as well as the dramatic developments on the legal and judicial plane. They have engaged in diplomatic protest, suspended military exports to Israel, closed their ports and airspace to arms shipment, and imposed sanctions on the ministers, violent settlers, and settler organizations. There's also a growing movement involving at least many in civil society to ban trade with Israeli settlements in the West Bank, including East Jerusalem, and there's some momentum with states, although, as already noted, all too often, these responses by third states, and especially by Israel's closest and most influential allies, have been too little, too late. Now, before speaking about legal obligations that third states have, it's important to note that the primary duty bearer here is the state perpetrating the violations, that's Israel. So Israel's obligations include, in the first instance, a duty to comply with its legal obligations under international humanitarian law, or the laws of war, both the rules on the conduct of hostilities, so the rules that regulate how you fight in hostilities, and the rules applicable to military operations and to the law of occupation, the body of law that's most relevant, for example, in the West Bank. On top of this, Israel has to respect its obligations under human rights law, which apply in the situation. Israel doesn't accept that, but it does. It is bound by human rights law in the territory. Israel must also respect other relevant bodies of international law, branches of international law, including, notably, the prohibition on genocide and what we call the jus ad bellum, the body of law that prohibits actually starting an armed conflict to begin with and set certain limits on the duration or the circumstances in which you can continue to control foreign territory. Israel must, of course, also comply with judgments, decisions, and orders by the International Court of Justice that were addressed to it, the ones I just referred to. In case Israel commits internationally wrongful acts, by the way, this might sound a bit like science fiction here. I'm describing what's supposed to happen. You will juxtapose this with reality and see that there's a gap. But in case Israel commits internationally wrongful acts, then there are secondary rules on state responsibility that are supposed to come into play. And these require, first of all, that Israel must cease any unlawful acts, offer assurances and guarantees that it will not repeat these unlawful acts, and must make full reparation for any injury caused by violations of international law. And these reparations may take the form of restitution. That means restoring the situation as it was before the breach. How you do that in the case of an occupation that has gone on for well over half a century is quite difficult to work out, but that's one of the obligations. Otherwise, monetary compensation. Again, how you would calculate the accumulated harm from decades of occupation and rounds of hostilities, including the most recent one, is quite, would probably be quite a daunting task. And then finally, there's this notion in international law, which I don't think is very satisfying, although it's called satisfaction, where a state offers a kind of apology for its actions. If I had to bet which of these would eventually happen, then that might be the most likely. But as you can see, a lot more is supposed to happen in theory. Israel, of course, also has an obligation to investigate and prosecute suspected individual perpetrators of international crimes. That's not very likely to happen when the main perpetrators of the international crimes here include the Prime Minister, the Minister of Defense, the Minister of Internal Security, etc. But so those are the obligations that the state itself has, and often states are not particularly motivated to promote justice or to discharge their obligations under international law. These are done as part of a state policy, certainly in this case. That's why it's important that other states discharge their obligations. So what are these obligations? So they're quite elaborate, actually. First of all, pursuant to the very first article in all of the 4 Geneva Conventions, third states have an obligation not only to respect international humanitarian law, the laws of war, but also to ensure respect for that body of law. This means that they may not encourage, aid, or assist in the commission of violations of IHL, and they must take all feasible measures at their disposal to prevent such violations and to bring ongoing violations to an end. Third states must also take all reasonably available measures to prevent crimes against humanity and genocide. Furthermore, the basic rules of IHL, the right to self-determination, as well as the prohibitions of aggression, genocide, crimes against humanity, are all what we call peremptory norms of international law. That's the name for higher order norms from which no derogation is permitted. And these types of norms, these peremptory norms, give rise to obligations erga omnes. That means obligations that are owed to the international community as a whole. In case of serious breaches of peremptory norms, and we have seen many in the context that I'm speaking about, all states have an obligation under the law of state responsibility not to recognize the unlawful situation resulting from such breaches. So, for example, if an occupation is found to be unlawful, you're not supposed to recognize it as though it is lawful and engage with the occupier as though it's doing something that's lawful. Not to render any aid or assistance in the maintenance of this illegal situation, and to cooperate by lawful means to bring the serious breaches to an end. The erga omnes status of the norms in question furthermore entitles third states to invoke Israel's international responsibility for any alleged breaches that it committed and to demand their cessation as well as performance of the obligation to make reparation. So if they wanted to, there's quite a lot that states could do, and in some cases actually have a legal obligation to do. Now, I mentioned quite a few different proceedings. I'm going to speak with a little more detail about the obligations that arise from the finding in the advisory opinion that Israel's continued presence in the Palestinian territory is unlawful and must end as rapidly as possible, in part because the court, realizing that just saying what Israel has to do wouldn't result in very much, went to the trouble of articulating third states' responsibility. So, actually, what the court did is really to put into practice a lot of these sort of abstract points of law that I mentioned before, and it determined that the detailed obligations for third states are, broadly speaking, I won't go into all the details for lack of time, but just to sort of describe them in a structural kind of way, they're all really articulations of the 3 general legal consequences that follow for third states under the law of state responsibility in the case of serious breaches of peremptory norms. So, non-recognition, you don't recognize the unlawful situation as though it was lawful, non-assistance, and cooperation by lawful means to bring the serious breaches to an end and to ensure respect for international humanitarian law. So I want to say a little bit about how this might be drawn into concrete conclusions. So in practice, the positive and negative obligations set out by the court in some detail, I skipped that, often involve a form of diplomatic, political, and economic pressure on a state, either in isolation or collectively. So, taking all this together, what can and should third states do in practice in response to the advisory opinion, as well as concerns of serious violations of international law that have been committed and are still being committed in Gaza and the West Bank, including East Jerusalem. So here are some examples, and this isn't an exhaustive list. But first of all, states should fully align their public positioning with the finding of the International Court of Justice in its advisory opinion, including on the illegality of Israel's continued presence in the occupied Palestinian territory and of its policies and practices implemented in those territories, in that territory. This is actually very relevant in the context of the so-called Trump plan that has come about recently for the future of Gaza, following the recently concluded rather fragile ceasefire. The Trump plan speaks about Gaza as if it was an entity separate from the rest of the occupied Palestinian territory. It doesn't even mention the West Bank or East Jerusalem. There's no reference whatsoever to the relevant Security Council and General Assembly resolutions, or to international law, actually, including the court's findings in its advisory opinion, and no firm commitment to Palestinian statehood in the parameters recognized by the international community, that is, the West Bank, including East Jerusalem, and Gaza. So there's already a gap between what's required and this Trump plan that's been embraced by so many states. Third states should also revisit existing agreements with Israel as to their scope of application and refrain from applying provisions of agreements in force or entering into new agreements that include the Palestinian territory in their scope of application. So Israel has sometimes signed agreements with other states that suggest that Israel encompasses part of the Palestinian territories. No state should sign such an agreement or continue to abide by such an agreement. Furthermore, they should ban the importation of goods produced in settlements, the exportation of goods to settlements, as well as the provision of services to and investment in settlements in the occupied Palestinian territory. I mentioned before, civil society organizations are increasingly exploring what this would mean. There's a great deal of economic engagement with Israel, including with the settlement enterprise, which Israel doesn't really distinguish from its own territory. This could have far-reaching implications, and it could be an effective means on putting pressure on Israel to end its unlawful occupation, but that depends on states actually doing what the International Court of Justice suggested they should do. In addition, given that many Israeli companies also operate in the settlements, states should at least establish explicit guidelines as to which business relations with these companies assist in maintaining the illegal situation, and these should be terminated. So you're not supposed to assist under the ICJ in maintaining Israel's unlawful presence in the occupied Palestinian territories. Certain engagement with Israeli companies could indirectly or directly do so. States should also suspend the transfer of arms and military equipment, as well as other forms of assistance to Israel, to the extent that they may be used to maintain the occupation, or in a case of a credible risk that they may be used to commit violations of IHL. Of course, the recent Israeli military campaign in Gaza created at least a credible risk that the munitions would be used to commit violations of IHL, and munitions should not have been provided. And based on that record, they shouldn't be provided. One could also argue that third states should suspend not just the export of weapons to Israel, but also import of weapons from Israeli military companies. In that regard, it might be interesting or perhaps disturbing to notice that there's actually been a boom in Israeli sales of weapons. The Israeli economy, after 2 years of armed conflict, hasn't really taken a very strong hit. And part of the reason for that is that it's demonstrated its weapons now in Gaza to potential purchasers of those weapons. That might be a good reason to rethink whether this is a state from which weapons should be purchased. In addition, third states should set up international mechanisms, including a register of damage for the OPT, actually as the Council of Europe did for Ukraine. This is one of many examples where you can find a bit of discrepancy between the response with respect to Russia and the Ukraine and Israel and Palestine. A follow-up mechanism should be set up to investigate the court's finding. I didn't mention this before, but it found that Israel violates Article 3 of the International Convention on the Elimination of All Forms of Racial Discrimination. Article 3 prohibits racial discrimination and apartheid. The General Assembly, the UN General Assembly, actually called for in a resolution for this kind of a mechanism to look into these Article 3 violations. States should follow. Third states should also consider taking measures of retortion. So that's a kind of measure where you respond to a violation with, and create sort of hardships for the states that's committing the violation. For example, cutting diplomatic ties or suspending voluntary assistance. They could also adopt so-called countermeasures. Countermeasures are a bit more extreme than retortion. These are cases where you respond to a violation of a fundamental peremptory norm of international law, or an erga omnes obligation, with measures that would ordinarily be unlawful, but they're considered lawful when you're implementing them to create pressure on a state that's breaching its own obligations. So, for example, imposing a trade embargo on Israel, freezing assets belonging to the state, etc. Again, this sounds like science fiction when you talk about doing this with respect to Israel, but it has been done with respect to other states. We're seeing this happening now, rightly, I think, in response to Russian aggression. They could also consider imposing targeted human rights sanctions, travel bans, and asset freezes against high-level Israeli officials, those responsible for maintaining the occupation and for directing and encouraging violations of international law. We have a minister that's speaking all the time. Well, we have a few, but one who's particularly outspoken, Smotrich, speaking about very openly about plans to annex this territory and doing everything he can to turn that into a reality on the ground before it's a formal policy. It would perhaps be useful to target people like that. Finally, states should vote in favor of resolutions that concern follow-up action to implement the findings of the court and to bring all violations of international law to an end. Again, the Trump plan for Gaza, which completely sidelines Palestinian decision-making and casts grave doubt upon a future realization of the Palestinian people's right to self-determination, as well as a parliamentary vote that took place in the Knesset just this last Wednesday, in which the Knesset was proposing to enact a law that annexes the territory over which it, under international law, has unlawful control. All this underscores the urgency for states to adopt the kinds of measures that I've been describing now. I haven't been looking at time, so I need someone to indicate to me, but otherwise I'm going to continue because I have quite a bit more to say. I should stop soon. Okay, now it's 5 minutes, I'll try to do that. Okay, so it's also worth noting that third states have availed, well, I've said this actually, they've availed themselves of these options quite extensively in other contexts, so worth remembering. I won't go into much detail about this, but I referred to measures to ensure that Israel discharges its obligations. International law also imposes obligations on individuals, and certain violations of those obligations that individuals have are defined as international crimes, such as war crimes and crimes against humanity, the crime of genocide. And there's also a need, first of all, for Israel, but failing appropriate measures by Israel, for third states to take action against the perpetrators of those violations. I mentioned before that the International Criminal Court has already issued arrest warrants against, among others, Israel's prime minister. Some states, including here, have indicated that they're not going to, or they're going to try and find ways to work around this arrest warrant, even though they're party to the Rome Statute, and are actually obliged to detain someone against whom an arrest warrant has been issued. That's very troubling for the context and also for the rule of international law. So I'll skip a bit and perhaps draw to a conclusion quickly. As I mentioned, third states have a robust set of obligations emanating from the International Court of Justice's landmark advisory opinion from July 24 and from general international law. The ceasefire now being put in place does not relieve Israel or third states of their obligations. We've been seeing some troubling indications that third states are very excitedly embracing the ceasefire to forget about the whole history with a kind of, it seems, the mirage of peace, and it still seems very much a mirage of peace is being used as an excuse to set justice aside. It's inconvenient to pursue justice. Important to resist that. So as the ceasefire is being put in place, or this plan is being put in place, there's still grave concern that Israel will double down on its course of moving towards full annexation in the West Bank, and that it will do so without relinquishing its control over Gaza as well. So this would mark an even sharper departure from what international law requires. And again, this is a concern, first of all, for the people of Palestine, who have been the targets of the violations that Israel has been committed and will face the consequences if it continues on this course. It's also a threat more broadly for, as I mentioned, for international law, for a legal framework that was set in place largely after the experiences of the Second World War, when the world reflected in horror on what had just transpired and agreed that we have to change course, that there has to be more effective constraints on power, that there has to be a set of limitations that are respected. And that has held up to a degree up till now. But the developments that we're seeing in Palestine, in Israel and Palestine, especially when you consider them alongside broader developments globally with a president in the United States who sort of treats international law with disinterest or disdain, disregard. Other powerful actors who are increasingly acting in open defiance of international law. This is a dangerous moment, and it has to be responded to. Unfortunately, states are not living up to their responsibilities yet, and I think it's crucial that civil society, particularly in the states with the most capacity to exert influence, do everything they can, continue to do everything they can, despite their oppression that they suffer for doing so. I understand that you heard a little bit about that in the German context. We obviously have that in Israel, certainly in Palestine. But it's crucial that we push our states to respect the obligations that they committed to respect. So I'll stop there for now, and thank you very much for your attention.
Thank you, Dr. Eitan Diamond, for this very thought-provoking and also concerning talk. It's great to get your perspective from the system from within. And I also want to give you the opportunity to ask maybe a couple of questions. There are some questions in the back.
Thank you, Dr. Diamond, for your very fantastic talk here, laying out the international law. I'm kind of interested in the dialectics between, or the dynamics between the international and the national law, because as you said, rightly so, this will shift to some domestic courts now, third state courts. But before we go to third states, maybe I have two questions for you regarding the Israeli judiciary. Mm-hmm. One, if you could say something about whether any cases of incitement, genocidal incitement, were taken up, and not just submitted, but also really, investigated by public prosecutor and then, dealt with by the judiciary. That would be one case, because the entire field of incitement, you mentioned some of these, I'm sure, as you know Hebrew, the media and the entire public discourse is full of this incitement, ongoing, right? So that would be one thing. And the other thing would be, if you think, both kind of factually and legally, you can still uphold this idea that whatever happens in occupied territory is not immediately connected to what's happening in Israel. So because you referred to the ICJ advisory opinion that third states were obliged to stop or end as rapidly as possible any also kind of treaties, etc., that uphold the illegality of your occupation. But then when you look at the banking system that makes possible the settlement building, it's immediately connected to Israel. When you look at the sewage system, when you look even at the court system, when you look at the street system, the transportation system, when you look at so many of these systems, it's impossible to uphold something legally as two different zones when factually it's actually one. Yeah. So maybe you could say something about these two things.
No, thanks for those really good questions. But I don't have nice answers for those questions. So first of all, on the incitement and many other crimes that were documented, There hasn't been, it hasn't even reached the courts in many cases because the prosecution hasn't decided to. I mean, to be fair, if they wanted to prosecute everyone who engaged in incitement in Israel, that would be a very large percentage of the population, including many of the leaders of the state and every kind of establishment within the state. That's actually part of the problem. If you don't enforce the law, you don't actually convey to people that you've crossed the line, then the line just moves, the norms change. We've seen soldiers, I mean, I'm sure you've seen these clips of soldiers documenting themselves committing war crimes gleefully and publishing it. That kind of culture of impunity is a consequence of a failure to enforce the law, a systematic failure. But I will add that there have been cases that have been brought before the courts. There's a vibrant Palestinian and also actually Israeli civil society still that tries to pursue justice through the channels that are available in the Israeli judicial system. And sometimes it's just to illustrate that the system isn't actually functioning. So there have been efforts, though. In this case, I think it wasn't just to illustrate. It was to try and spare a great deal of human suffering. This was about the detention and conditions of detention. So thousands of people have been detained by Israel in the war, many of them without any kind of due process through this incarceration of unlawful combatants law that was created and has been interpreted in a very expansive way, and other measures that allow for detaining people not because you've prosecuted them or proven that they've done anything wrong, but because the state alleges that it has grounds for concern that they pose a security threat. So there have been efforts to challenge, first of all, the fact that these people have been detained, but more than that, their treatment under detention. I'm sure people have seen some images of what people look like after they've come out of detention and heard the accounts of their treatment. This is partly facilitated by the total absence of any oversight over the treatment. The ICRC, I used to work for the International Committee of the Red Cross in the past. The ICRC always visited detainees. They had been denied access, so has everybody else. So you have people in this context with this level of hatred put in Israeli detention without any criminal accusation, any kind of evidence being presented, and completely at the mercy of the prison guards when you have a minister like Ben-Gvir in charge of the system. And as one could expect, what results is terrible mistreatment of people. Efforts to try to achieve some justice before the court have all failed. The court has basically deferred decisions. It's accepted a request by the state to defer its decision again and again and again, and people, thousands and thousands of people have languished in Israeli detention facilities and endured torture and other forms of ill treatment without any real access to courts for all this time. So in that, I will just mention that there is a history of, when one talks about international crimes, of attributing those crimes to all kinds of actors in the state system. In Nuremberg, there were judges who were found guilty of having a role in crimes and jurists. I think there's going to have to be a reckoning for the people who allowed this to happen, for this culture of impunity to evolve. So that's on your first question. And then the other question, you're absolutely right, that the system in Israel is designed in such a way that you can't see, unless you're Palestinian, the border between Israel and Palestine. The green line disappears for Israelis and for Israeli corporations, while it's set in high concrete walls for Palestinians. And that will, of course, create these complications when you try to implement sanctions against company. But I think the burden should shift. So it shouldn't be for the person importing goods from a supposedly Israeli company or engaging with an Israeli bank to try to disentangle the kind of connections that this enterprise has with the Israeli settlements. You have to shift the burden of proof and presume that they aren't assisting in maintaining the settlement enterprise, which they often are doing, unless they can prove otherwise. Yeah, thanks.
Okay, eine Frage hier.
Thank you very much for this great presentation. I will try to be short. So my name is Bojan Gavrilovic. I'm also a human rights lawyer. First question is this challenge to the charge before the ICC based on the immunity of state officials that came up after Netanyahu was charged, and that was not mentioned when Putin was charged, and this should be the same situation because they are both in office, right? Mm-hmm. So many states are now supporting this argument. I read about France, but there are probably others. The second question is concerning the obligation of third states and Israel. And I'm working on reparations in Iraq for the crimes of Islamic State, and I think it carries a great potential to put forward, to make a case for reparations for Palestinians, because they are really a good tool for repairing the harm. And we have transformative reparations. You didn't mention rehabilitation. And as you said, you know, in Ukraine, there is a register of damages. So these European states should at least do the same for Palestine. And from my experience, I think this decoupling from criminal accountability and reparation is crucial, because it doesn't need to be genocide to trigger the obligation of states. And then you have this other line of argumentation, and you can hopefully be more successful. Thank you.
Thanks a lot. So on the first question about this kind of double standards and regression in the approach towards accountability for leaders of states, I mean, I mentioned that the concerns here about the attitude towards third states' obligations with respect to Israel and Palestine have wider implications for a law-based international order, and your question kind of illustrates that. So when states in the same sort of factual circumstances take one approach with respect to one actor and another approach towards another one because they dislike the one and have a friendly relationship with the other, the law doesn't look like law anymore. It becomes just a kind of tool that you use for political means. And you can't expect that a system that calls itself law but functions just in this kind of whimsical way will have any effect and will command respect. So this is concerning in one sense because of these double standards and the way those undermine the credibility of international law, and also because in order not to have to prosecute Netanyahu, and probably, I'm speculating here, but I imagine there's some calculus about the relationship with the US and how that might be effective by prosecuting Netanyahu. Because of these kinds of considerations, we're seeing an erosion in the system, in the nature of these norms of international law. And if you eroded them so that you don't have to detain Netanyahu and have an awkward conversation with Trump, then they're not going to serve you later on when it's Putin on the dock and others. So that's just a little bit in relation to your first comment. I agree with you regarding reparations. I think another added value for reparations would be that it wouldn't be so easy to maintain an occupation and to conduct a military campaign in the way Israel just did in Gaza if you had to actually pay for the consequences afterwards. That could, in addition to the threat of kind of individual criminal responsibility, in theory, if you actually had to pay for the costs of maintaining an occupation for decades and decades and provide reparations when you do so unlawfully, that might create a deterrence. In fact, the law of occupation was designed to create a deterrence for occupying powers. International law treats situations of occupation as a kind of aberration. They're supposed to be temporary and to end as quickly as possible. And in order not to create incentives for states to acquire territory by force, the law imposes a lot of obligations on the occupying power. Israel has managed to outsource those costs. It doesn't look very likely that Israel is going to foot the bill for the reconstruction of Gaza. It doesn't pay the cost of its occupation in the West Bank. That's borne by Palestinians in their suffering and by others who provide funding for them, by a humanitarian sector that's funded by others. So absolutely, it would be very good if we were able to organize ourselves in such a way that the demand for reparations that the International Court of Justice made, the General Assembly called for, would be respected. Unfortunately, we have a political constellation that isn't committed enough to the law and has a different kind of calculus, so that's not happening yet. I realize it's a lot of burden for actors in civil society to carry, but I fear we have no choice at the moment. The states have their political incentives, their extra legal incentives to behave the way they're behaving, and we have to try and push, all of us, as much as we can to change that and pursue justice.
Thank you very much, Dr. Diamond, for these great words. Unfortunately, we have to close the discussion now. I'm sure Dr. Diamond will be around to answer your questions personally. We want to move on now to the media panel, but I think this really was a great addition to our program, and we have to work together internationally with all the people that are interested in upholding international law and international human rights law. And Dr. Diamond, thank you very much for your contribution today. Thank you.